Advocate Busisiwe Mkhwebane is back in court challenging her suspension. Let's cross live to that.
I want to make two important points here, which relate to questions that were posed by Justice Francis. The first one is this. And again, it's this issue about the Constitution says what it says what it says. 194.3a specifically uses the word may, right? What the president may suspend after the start of the proceedings and so on. Contrast that to 194.3b, which says the president must remove a person from office upon the adoption of the assembly of a resolution. For lawyers, what is the implication of that? It means that this idea of protecting the institution cannot be properly used as, let's put it this way, as an excuse or as a reason for using the powers prematurely. Because if that was the real intention was to protect the institution or the organization, then it would say the president, once the serious allegations have been made, must suspend. After all, he has to protect the public and what and all the institutions. The mere fact that the constitutional writers use the word may, it was indicating that they realized that even in the case where there are serious allegations, the president still has to exercise a discretion. Now, that then goes to, and because I don't have time, I'm not going to go through all the, I'll invite the court in your own time, my lords, to look at the letter of representations where we put chapter and verse of why the president's reaction, or rather suspension, would be A, inappropriate, and B, premature, and C, in conflict. And he ignored all of that. And we even showed him that this so-called motion of Mazoni MP is so unlikely to pass the two-thirds majority. All those considerations and how long the process is likely to take, a president who actually wanted to protect the organization would not have suspended, because he would have realized that this public protector has been here, these charges have been here for 2 years. The sun did not come from the west. Instead, she actually had 2 clean audits in that period. So there is no crisis, quite frankly. And so he would have realized that none of his actions explain this big rush. The big rush can only be explained by what I'm about to say now. The other point related to this point is this. If you go to page 401, that's volume, I'm assuming it's volume 5. Or anyway, the rules are found everywhere. It's rule 129 AD. This version is on page 401.
That is bundle A.
Bundle A, my lord. Yes. There's another giveaway, because a question was posed to me. Well, there's only one committee. But as I say, I'm not being rude, but that's the problem of Parliament. It's not the problem of this court, with the greatest respect, and it's certainly not the problem of the public protector. The committee that was set up says at 129 AD, it's very clear what its mandate is. The committee must, when the Assembly has approved the recommendations of the independent panel in terms of 129Z, proceed to conduct an inquiry and establish the veracity of the charges and report to the Assembly thereon. Full stop. If Parliament, maybe after this case, once this court or the higher courts point out that there is this gap which we debated this morning, then Parliament, of course, is free, for example, to expand the mandate of this committee. Let me put it this, it would be wrong legally, but so it might be challenged. So I don't want to set them up for a challenge. So they could say that committee will determine the veracity and then conduct the removal proceedings. That would close that gap. But if the gap is there, it's not our problem, so to speak. But for now, the mandate of the committee is confined to establishing the veracity and report to the Assembly. So that's just the points that I wanted to clean up on the... Sorry.
If you have a removal committee, what is the purpose of the National Assembly?
Well, the short answer is I don't know. But the long answer is this. There is nothing, it's conceivable, Justice Francis, that the founders of the Constitution, let's assume, just work with me for a minute, assume that they conceived such a thing as a removal committee. Okay? Now, they might have had the situation that we were talking about earlier in relation to the JSC. Because actually, in the example I was giving you of judges, the JSC, the small JSC, is, once the finding is made, becomes a removal committee. Because by then it's seized with only, once there's a finding that says there's gross misconduct on the part of a judge, then the JSC, for all intents and purposes, sits as a removal committee. Because and it happens, it takes a long time. You know, it might look on paper that, oh, well, it's just, you know, to press a button and send a fax or whatever. No. The JSC can be seized, as would such a committee be, with this matter. It can be very complicated, and I'm talking from personal experience. It can be very complicated as to, for example, whether you make the recommendation for a suspension. Remember, the JSC, when it sits at that point, one of the functions it must make, I think it's 177.3. Yes, it's 177.3. Yes, the President, on the advice of the Judicial Service Commission, may suspend a judge who is the subject of a procedure in terms of subsection 1. What that means is when the JSC sits in the manner that I've described, then the President may suspend in the same way as 194.3a. So the short answer is that committee would perform the exact function that is performed by the so-called small JSC, which is to process the motion, send it to the speaker, whatever. It should have been defined in the rules. That if it wasn't, it wasn't. That's their problem. So they could have said, for example, this same committee will also sit as a removal committee. But on the rules as they sit now, and on the Constitution as it sits now, it is not. And with the greatest respect, the question is, really, it's a conceptual problem. Because you have to look at it this way. You have to almost assume that there were rules, and then there was a committee, and then the Constitution was written, knowing that there is a committee. But it's actually the other way around. 23 years later, the rules were written. So if the rules don't speak to the Constitution, that's a problem that the court cannot resolve. Because if the Constitution conceived of such a thing, let's say the Constitution conceived of an appeal from this committee that's sitting now, and it says you can suspend after the appeal, but the rules don't have an appeal committee. The court can't cure that by saying, oh, well, we'll just use this one that we have, this committee, when they failed to actually constitute an appeal committee, and I'm using that example just for emphasis. But the crucial point is that the word may is a giveaway that even if all the conditions were met, the president doesn't have to, there's nothing compelling him to suspend. Nothing.
And just on the, I just want to be sure that I understand the argument correctly. In other words, if your alternative argument to be accepted, the constitutional power for the president to suspend, if I understand correctly, in this case will have only been triggered after there was informal commencement of the proceedings.
Absolutely.
The case will be the 11th, you understand?
The 11th, yes. On the alternative, that's correct, Justice Lukuli. On the alternative arrangement, argument, assuming I'm wrong on everything else, the commencement would have been on the 11th. But the giveaway is that then both the triggering of the 17th of March and the 9th of June fall before the 11th. So still the suspension would be unlawful.
Yes, now, on the interpretation, at the interpretation level, the commencement of the proceedings, or the start of the proceedings, you understand correctly, it will mean the formal commencement of the proceedings, not necessarily the federal of the matter to the Congress.
Absolutely. What we call, remember in Part A, we call them administrative. Yeah, like those meetings where they meet and say, let's do scheduling and so on. Those cannot, the constitutional writers' role really could not have thought, well, if we just meet and say, okay, are we going to meet in room 25 or in room 26? They call that, that's a point at which such a big constitutional matter must happen. It must mean something which has juridical value, which happens where the guillotine falls somewhere. And firstly, it must be known and knowable, not this fuzzy stuff that we're getting. But secondly, it must be, it's like saying, in fact, I wanted to make this example to Justice Nuku before tea. When we were saying, well, they're saying no, maybe. It's like saying you can only vote when you are 18. There's a date. You can't say, no, well, if you look a bit 18, and so it must be on a knowable date that on your 18th birthday, now you can vote. Everyone knows it. It's on, in my case, 26th of September. You turn 18. That's it. It can be, no, well, what about, let's look at the values and maybe, no. So, right. So let's then come back, because this links to the point that I was making. Justices, I'm back with the conflict point. This is, let me just do this for 2 minutes, just to paint the real picture of what we're dealing with here, which is a gross abuse. So you have the agreement. Let's talk about the agreement. Agreement between council, which we invoke. That agreement is not, there's no debate about it. Any debate about that agreement is just contrived. Paragraph 3 of the agreement is very clear. It says, the president will receive your, I don't want to speak as if I'm a witness. Let me just speak on the basis of the affidavits. There's a debate. You have to look at, to see why this thing is being fudged. Every time the president deals with that agreement, he doesn't deal with the letters that are before the 30th of March. Nowhere. And you know why? Because in the letter of 30th of March, or rather of 25th of March, he said, I will not suspend until the outcome of Part A, provided the matter is heard on the 26th of April. Simple. No complexity there. The DA wrote him a letter, a big complaining letter, saying, how dare you do this? You should suspend, you should have suspended yesterday, and so on and so on. How can you allow this, and so on? President wrote back to the DA and said, I know my obligations. Thank you very much. Basically, it was like a very curt letter. So the 26th of April, which was supposed to be the start of these proceedings here, is moved to the 18th of May, okay, for issues that don't concern us now. So all we were saying, we then say to them, let's restore that agreement so that you can only suspend, if you have to, after the outcome. So that's why that agreement, the SMS, the WhatsApp, is on the 20th of May, because it's the day after we were here. I stood in this very spot and I said to Justice Erasmus, because I was rushing for an aeroplane, so I said, my lords, because we don't have a lot of time, I was going to address you about making an interim arrangement, a holding arrangement, because the justice said, we know this thing is urgent, we might even just give you an order next week, and so on and so on. So I said, I was going to address you to make an arrangement. And I said, you'll see in that transcript, I said, but myself and my learned friend, Ms. Pillay, have been working well together. I'm sure that I don't have to address this now. We will have some arrangement outside. And the matter was left on that basis. That's the 19th. I moved from here, took an aeroplane, gone to Joburg. 8 o'clock, you'll see that message, 8:05, to council to say, let's have that arrangement about holding until the outcome of the. And then it comes back with a counter, which is what is in there. And it's conservative, but it's understandable. They say a very simple thing. No, give us the representations. The president will then consider whether to make any undertaking. And he will come to you and advise you if he's making such an undertaking. If so, he will tell you the terms thereof. So I talked to the client, she's happy, no problem. Because this is clear, the reason we want that window is so that if there's a threat of a suspension, we can go to court if we have to or whatever. That's all. We just want to know whether he's going to suspend or he's not going to suspend, or whether he's going to give us the undertaking. No. Boom. On the 9th of June, suspension. No notification. Nobody has said, no, that undertaking is, we're not going to give it to you for this or that reason, or we're going to give it to you. No. Why? Because there's a rush about Palapala. That's why. So so that's the first thing. The second one is the one I said before lunch, my lords. With all that background, at some stage, and I admit that the undertaking kept on changing shape and getting more and more conservative. I'm not there. But one thing that is sure is that at some stage, somewhere in March, they were prepared, and that's why the DA had to scold them, to give an undertaking until the outcome. They knew the importance of that word, until the outcome of the proceedings. In fact, for all the criticism that I've given to the Part A judgment, there's one paragraph that is good there, at least. It says at paragraph 14, praising the president. Again, as accommodation, the third respondent, that's the president, agreed to delay his decision. You'll find that on 250. Agreed to delay his decision on whether to suspend Advocate Mkhwebane, so that she would be presented with an opportunity to challenge his right to do so. It can be clearer than that. If she was going to be given an opportunity to challenge his right to do so, and also the right to proceed with the impeachment inquiry, then surely it says what it means and it means what it says. So, but the point is this: who in this country has a right to give the middle finger? I can't put it any more polite than that, to the courts and say, I know there's going to be a judgment. I know there's a challenge. I was a party to those proceedings. But you know what? I don't care what the court is going to say. I'm just going to do, if we can allow that in the name of whatever, I don't know, that any party must say, if the president, no less than the president, can say, the court is seized with this matter, I know it's coming, and I say again, let's grant him, let's say he didn't know that it's coming tomorrow. Let's say he just knew that it's coming urgently. I know that it's coming soon, but I don't care what the court says, I'm suspending. As lame as a chain. Who does that? Who does that? You know? And if we allow that in this country, for anybody, then we're on the road to nowhere. Now, the president doesn't stop there. He breaks his own agreement. He breaches Section 165 of the Constitution, which says the courts must be respected. Precipitately a day before. But one doesn't have to be a lawyer or a genius to know why. Surely, this must have something to do with the questions he received from the Public Protector about the Palapala gate scandal. There's no other intervening, nothing. There's nothing else that happened for him to do all these activities, except that he received questions which were uncomfortable about possible criminal activities on his part and activities that might result in his impeachment. And then he comes here and tells us this application that is being brought now to say, oh, well, he says firstly in the papers, I don't know what the fuss is about. I have fully cooperated with every investigation. Where? Firstly, he's given to respond. He says, no, he's exceptionally busy. Exceptionally busy. In that period where he's exceptionally busy, he hosts an Ankole sale farm, auction on the 18th. This is remember he got the letter on the 8th. More than 20 days later, in the period of exceptional business, where he can't attend to 31 questions about something that happened 2 years ago, he does that. And then he's given not the 7-day statutory period, he's given another almost a month, just less than a month. He doesn't meet that deadline. Again, exceptionally busy. Until he's threatened with a subpoena. And then he complies with the subpoena on Friday, which means if on Monday last week he couldn't comply, but he was able to do it within 3 days, once the subpoena came out, then it means he could have done it on the 11th of June. But that's not enough. Then he says, no, I'm not going to give you the answers. You, the court, and us.
But it doesn't say so. He says that it's prepared, he will abide what the court says.
Yeah.
Just want to bring it to the attention of the court that it has been conveyed to this bureau.
Yes.
The answers should only be provided to the office.
Yes. No, that's what he says. I know. That's why we did the counter application. But a person can say anything they want, Justice Nuku. We have to scrutinize the facts. Context is everything. What is the real problem? Nobody.
There's an email there which is revealing that
he invokes. Yes. No. Fair enough. But the point I'm making, Justice Nuku, is that if someone is really so willing, in the name of transparency and all these good things, to assist, then they say, we will make an arrangement for, and I'm just thinking off the top of my head, we say this in our application, we'll make an arrangement that the answers will be seen either by the legal representatives or by the clients or whatever in chambers, something like that. Why? Because it's relevant to his claim under oath that he has fully complied. How do we know that is true? What if those answers are just the letters of the alphabet?
But that's not for this court to deal.
Well, he said it in this
All
court.
that this court must do is scrutinize whether his conduct accords that constitution required?
No, if that was so, then he would never have told this court in his affidavit 3 times that he has fully complied. If it had nothing to do with this court, he would have told anyone else who cares.
No, what I'm saying is that you don't have to follow every little piece of allegation. It must be relevant to the issue that the court says.
Yeah.
Here the applicant comes to court and says to the court that the conduct by the state actor in the person of the speaker, the president, and the chairperson of the committee is unconstitutional, valid, and lawful because of ABC.
Yes. Okay, I'll leave it. Yeah, no, that's fine, Justice Smith. Let me just leave you with this rhetorical question to ponder on. If what you're saying is correct, if the answers have nothing to do with this case, then why in this affidavit does the president say, I wanted to give it to this court? For what? Because it's irrelevant. So if the mere fact that he says, if it wasn't for the acting public protector basically gagging me, I would have given it to this court. For what? It's because he knows that he would have given it to this court because it is relevant. Otherwise, this court is not here just to get pieces of paper that don't mean anything. He knows, Justice Nuku. That's why he did an affidavit on Saturday and said to this court, you'll forgive me, I'm not going to give you the answers. But that's fine. Let's say that it's he was here. Yeah. Well, the issue. The issue. Well. Yes. Section 7, Rule 7. I keep on calling it Section 7. Yes. Anyway, look, the point is quite simple. If there is no other explanation except for the conflict for breaking the agreement, for breaching Section 165, for being in contempt, and really, at some point, we must not underestimate the intelligence of the public, because the public knows that the person got answers, questions on such and such a day. 24 hours later, they suspended the person, and a few days later, they were stuck without being able to give answers. So unless if there's another explanation, maybe it will be given, then it is clear that the Palapala Farmgate issue is a source of a disqualifying conflict of interest on the part of the president himself. There's no two ways about it. It's the biggest problem that he's facing, and it is the author of the 31 questions cannot be expected to be subjected to the neutral decisions of the person that they were investigating. Then the other reference I want to make is at page 1079. That will be volume 11 of Part A. I won't develop this. It's just the cover page of the unsealing of the CR17 cases. You'll see that it says Economic Freedom Fighters versus Matamela Cyril Ramaphosa, first respondent, and then 1079. And then the president somewhere makes it look like he's just a peripheral party. But at 1084, you'll see the judge actually summarizes the first respondent's argument. First respondents admitted the CR17 campaign has ceased to exist, and so on and so on. It was a private political matter. And this is the problem when you try to escape and something that's inescapable. Remember, in section 96.2 says, the president says, but these are all my official duties, there's no private matter. But here in this case, he says, it was a private political matter. So bringing himself directly into the clutches of section 96.2. The common law issue, again, is simple. I'll do it like this in shorthand, Justice Luke. We are saying, we accept that the law as it stands especially since the introduction of the Superior Courts Act, and read with Rule 45A, is that when you, unlike in the case of an appeal, when you appeal, automatically the judgment is suspended, right? And it doesn't matter, and again, we tried to explain this to the previous court, it doesn't matter if your appeal is good or bad or indifferent.
The default position.
That's it. It's the default position, the mere invocation, because that court was saying, no, but you'll see, they say it has 0 to 0 or whatever. It doesn't matter what the merits of the thing is, because it goes back to this issue of protection, Justice Francis. That is not just something that's put there for fun. It is to protect the person's Section 34 rights. To say you're right, what would be the point of appealing and then you win 2 years later, but the car, as we're talking about, is gone. So it's to protect the rights of the individual once again. Now we're saying a very simple matter. We're saying that rule, insofar as it is grounded in Section 34 of the Constitution, should be extended to rescissions. Because logically it's the same thing. If I'm saying I'm rescinding a judgment, it means I have a potential to reverse it, to set it aside, in the same way as I have a potential to set it aside on appeal. So what's the difference? But here's the shortcut. What we're asking for is the return. I'm sure all of us in here are old enough to remember Rule 4911. That was repealed by the introduction of the of Section 17 of the Superior Courts Act. Anyway, I'll paraphrase it. Rule 4911 said the following: whenever you put an application for leave to appeal or an application for rescission, the judgment is suspended. That's what the rule said. We all grew up under Rule 4911. And if you want a shortcut, what we are saying is that because the framers of that rule knew awaiting a judgment on appeal or someone awaiting a judgment on rescission. So if you want to cut all what I would have said if I had time, that relief is asking for a return to Rule 4911. Simple.
The argument against Contempt is that we now have Rule 45 capital A,
yes,
which provides this restriction. And there is no further challenge to the rule.
No, that's okay. That's just no. Fair enough. It's put there. I'm just saying that's just pushing technicalities to the limit, because that argument actually goes even further. It says that we should have also attacked Section 18. No. If it's just as I say, Justice Nuku. By the mere promulgation of Section 18, for example, that basically killed, quote unquote, Rule 4911, because now the bar was lifted to only appeals and rescissions were relegated. All we are saying is that if the adjustment of the common law as we propose is accepted, then Parliament will do what it has to do. The rule makers will do what they have to do. That's how these things happen. You don't.
That's like directing them to legislate in circumstances where they not detect that it is going to in the form of the final attack.
Okay.
I think that's the gist
of the defense. Yes. Well, yes, I understand that, Justice Nuku. The point I'm making is that the attack that we have mounted on the, remember, all these things emanate from the common law, but the common law itself must be interpreted in terms of Section 39(2) of the Constitution, progressively. I'm just using shorthand. It must be interpreted for a country which respects human dignity and so on. That's the fundamental issue. Does the rule as it stands, which it's almost like if these were people, you'd call it an equality clause. Does a rule that discriminates, quote unquote, between an appeal and a rescission meet constitutional muster when the fundamental issue is the same? Remember, what we're saying is that we develop the common law. That's what we're saying. We're not saying attack what rule this or rule that or rule that. We're saying you must develop the common law to accommodate this unfair discrimination, quote unquote, between the two things that should be treated similarly. Once that common law is developed, we didn't come here to say strike out this or that. It follows that once a court of law says that this discrimination between these two sections is unconstitutional, offends Section 34 of the Constitution, then everyone, all of us will have to do what they have to do. What is it called? The Rules Committee will do what it has to do. The Parliament will have to do what it has to do. The job of this court is simple and must not be complicated. It is not to draft some rule. It is to develop the common law, as it is enjoined to do in Section 39(2) when it does an interpretation, and as it is permitted to do in terms of 173 of the Constitution. That's it.
But does that not offend against the finality of judgment? Does that not consider
yes.
the finality of judgment?
Thank you, Justice Lukulin. Yes, the question is no, it doesn't. Because if it did, then to cure that defect, Justice Lukulin, we must then abolish the thing called rescission. Then we say, because we say, to protect the finality of judgments, once the court pronounces, that's it, right or wrong, especially if it's the apex court. You can say you can appeal and appeal, but at a particular point, that's it. If that's what the mischief wanted to cure. But no, the answer, therefore, to your question is no, it doesn't. Because if it offends the finality of judgment, then similarly, it must offend in terms of appeals. Yeah. And it's a simple issue of saying, as I say, let's return to the position that we all grew under of equating, to be honest. Rule 4911 equated the rescission and appeal in respect of the automatic suspension of the underlying judgment. That's it. Nothing more, nothing less. And we do that because that is affecting us, basically, directly. In this case, because if what was pending now in the Constitutional Court was an appeal, nobody sitting here would quibble about the fact that the Parliament and all sorts of places. They would know. But simply because it's a rescission this time and not an appeal, they feel that they are free to do what and they are, because the common law has been wrongly, or rather has not been developed fully to accord with this book, which is Section 34 of the Constitution. That's why they are able. There would be, if there was an appeal, there would be no inquiry going on now. There would be, all this debate would not even take place. In fact, after all, that is what the Deputy Speaker, Mr. Tsinodi, did. As soon as there was an appeal, he, of his own volition, without us having to bring a Section 18 application. Yes, Mr. Tsinodi, without us making a Section 18 application, voluntarily suspended the proceedings. Now let me move to quickly, if there's any need, to the Rule 7. The Rule 7 is a non-starter because it seeks to attack the right of Sianeho attorneys. Remember, the thing about withdrawing the application is gone now. So we just talk about whether the attorneys are empowered, which is what Rule 7.
Maybe we should address it in the slide, but I don't quite understand it because there seems to be no question about journalism drafted initially, and now all of a sudden in the middle of litigation, what is happening?
Yeah, nothing.
So perhaps very fast.
Yes, I'll deal with it in reply. Safe to say this, my lord. In Erasmus, it's explained.
It seems to be nothing more than to, for lack of a better word, because when she was suspended, it was on terms that she would retain all
Yes,
benefits.
absolutely.
And this must be one of those benefits.
Of course.
And now to want
To strip her. No, it's the indignity of it all. All these actions is to try and humiliate.
coming from state actors,
Yeah, maybe they'll explain better, but it's part of the campaign to humiliate and make sure that she is put out there to hang and to look like a person who is abusing state resources, because these documents are in their possession. And to invent this thing called the PPSA, or the Office of the Public Protector, or to latch on to the judgment, which is clearly wrong, at paragraph 77, which says the applicant here is the Office of the Public Protector. And then my learned friend says, yeah, look, if judges say that stare decisis, that's good.
Any other point you want to make?
If the court can just literally give me 1 minute, just to make sure that I'm not leaving out anything that's crucial, so that in fairness, my learned friends can. In the WhatsApp, I will address the court. I just want to attract the court to paragraph 3 of the WhatsApp. I won't develop the point now. Okay. Agency looks like it's not going to be an issue, but the abuse of court point is going to be pursued again by state actors. Thank you, my lord. If there's anything that I violently want to introduce, it will be obviously subject to my learned friend's right of reply. But those are our submissions, my lord, and I just want to round it off by ending where we started. The conduct of the president, in particular, in abdicating his powers, passing the buck to the speaker, acting in the way that we have catalogued in respect of the interpretation point only. Is it consistent with the Constitution? And is that, objectively speaking now, is that interpretation correct? Yes or no? Is the committee a removal committee, and has the time come? If it did, when did it come? Put that aside. Assume we are wrong. Then President Ramaphosa, faced with 6 investigations, all of which relate to impeachable offenses, including the one that is brewing up now. Can he, by any stretch of the imagination, be permitted, in the face of Section 96(2) of the Constitution, which says you mustn't, even the risk of a conflict, you must avoid? Can he be the person? The answer again is a big no. As the court pleases.
Thank you, Mr.
Thank you.
Masugu indicated that Mr. Simelane will
That's correct.
We proceed, Mr. Simelane.
All right, and so we come out of the Western Cape High Court there, the suspended Public Protector Advocate Busisiwe Mkhwebane challenging her suspension. Advocate Dalimpofu, SC, saying that the court must look at appeal and rescission and treat them properly, because he says what the old rule was, I think Rule 49, was that an application for appeal or rescission meant a judgment was suspended. Because of Section 18, that's been changed. And he's saying the Western Cape High Court must develop common law in order to make make sure that there is equality between those rules of appeal and rescission. Also saying that he alleges that Advocate Busisiwe Mkhwebane's suspension was because of Palapala questions that were posed to the president. Speaking about the word may as it was envisaged in the Constitution and by the writers of the Constitution, saying that there was nothing compelling the president to suspend the public protector because of the use of that word may. Bulelani Philip is following that story for us in Cape Town. Will give us more of a summary later on.